Arctic Haze are the FBI's investigations into the leaking of their investigatory work to the media. Guess who was leaking to the media? James Comey via Daniel Richmond. Look at the in-camera proceedings so you can confirm the baselessness of his claim that we shared anything with the grand jury at all, okay? We're above board here, Judge. Look at the files. We'll send them over. We're going to show you, we're going to give you these materials and show you that Comey's whining is completely and utterly baseless. James Comey and the prosecutors continue to battle over discovery and evidence. James Comey really wants to get his hands on these other materials, and there are a lot of questionable things going on here because the attorneys who are representing James Comey, one of them is this guy called Patrick Fitzgerald. And we now know that there were other search warrants that were executed against James Comey years ago, before this case was even filed, before Lindsay Halligan got even appointed in the Eastern District of Virginia. And Comey wants to review those materials, but the problem is James Comey apparently was also sending emails and classified documents to this same guy back at the time around the allegations of the lying. So this guy, Patrick Fitzgerald, was appointed to be James Comey's special counsel at the FBI, and then was also his attorney to whom he was getting documents sent from James Comey and to others, including Daniel Richmond, who is the guy who was supposedly, allegedly leaking to the media. The court said, "Good afternoon, everyone. This is Judge Fitzpatrick," hopefully no relation to the defense attorney. "And we're on the record in United States versus Comey. Who do we have on the line here for the government?" "Good afternoon, Your Honor." "Gabriel Diaz and Tyler Lemons for the DOJ, Your Honor." "All right, good afternoon. And who do we have for the defense?" "Good afternoon, Your Honor. Rebecca Donalski, Patrick Fitzgerald, Jessica Carmichael, all here for the defendant, James Comey, who's also on the line." "All right. And everyone, we do have a court reporter who is transcribing the proceedings. Shout out to Diane. So please speak slowly and please identify yourself before the government." "Defense. The government has requested that I review some materials in camera," which is in chambers off the record. "I appreciate that's the position the government takes. It seems to make sense to me. What's your position?" Defense attorney. "Thank you, Your Honor. We also appreciate the suggestion that you review these things, but our view is that the defense is best positioned to determine whether misconduct or irregularities occurred and whether those would be the basis for a motion to dismiss the James Comey case. First, the defense is most familiar with the defendant's attorney-client privilege, and we've got questions whether that privilege should still exist or whether or not the defense attorney who was receiving Comey's emails when he was still the director or just getting fired from the director, whether that makes him a witness in this underlying case. And the materials at issue, and second, the defense is best positioned to identify where the evidence came from, and so we want to see this material. Now, that being said, to the extent that there can be an ex parte submission from the defense with respect to what we've been seeing in the warrants and the privileged materials, we're open to doing so, but our view is that we've cited case law to this effect, and the defense is really best positioned to do this. So we want to see all of the evidence, even the grand jury proceedings, which are all usually under seal. "All right," says the judge. "So in terms of an ex parte submission, what do you envision? Like specifically, what would you be referring to that you want to see?" "Well, Your Honor, I'm referring to materials that we believe are at issue with respect to Comey's privilege. We've now seen what the agent saw from the materials obtained pursuant to the Arctic Haze warrants that were not reviewed for responsiveness and that are clearly privileged." Okay, Arctic Haze is different than Arctic Frost. Arctic Frost is the investigation into Trump. Arctic Haze are the FBI's investigations into the leaking of their investigatory work to the media. Guess who was leaking to the media? James Comey via Daniel Richmond. And Arctic Haze was the FBI really just playing with themselves. It's pretty disgusting. They opened like 7 investigations into themselves. Why are all these leaks happening? Where are they coming from? Turns out James Comey and the FBI, like the top people at the FBI. So they say, okay, we've now seen those and we've been wondering what those old warrants were, and that's what they were for. So that's one aspect of the submission. Of course, they investigated themselves 7 times and they found they did nothing wrong. The FBI, they're so dumb or malicious that they opened 7 investigations. Think of all the copy paper they wasted. They couldn't even find it. What was going on? It was Comey. He's like right next door in the office, sending stuff to Daniel Richmond. The second would be outlining what we've seen in terms of the materials that were produced by the government. And so we want to see the search warrants and more. All right. And when would you be in position to file this submission? Well, we could do that by tomorrow. All right. Prosecutors, any thoughts? Your Honor, we could provide the grand jury materials to the court in camera to you. I'm not sure what the ex parte submission is going to be on the defense's side. Like, what are they going to give to you that we can't see? But again, it seems that they are talking about information that would be attorney-client privilege or possibly gained, as they say, in violation of the Fourth Amendment. Now, neither of those two issues go to whether an irregularity occurred in the grand jury proceeding. That would be a basis for the dismissal of the indictment, meaning that something that occurred before the grand jury was so bad we have to dismiss the case. We cited several cases in our additional briefing that we filed before noon today. We don't believe that either of those issues would get them to be able to dismiss the indictment, and so we should not give the grand jury materials materials to James Comey. All right, says the judge. I understand that, and I apologize. I think I said Mr. Lemons. I'm getting to know you all very well. I think that was Mr. Diaz, correct? I apologize, Your Honor. Yeah, this was Mr. Diaz. All right, judge says, and I understand your position. And the question before me right now is really a very narrow one. Whether or not there is a basis under the rules for the court to make particularized findings necessary in order to require disclosure of the grand jury proceedings. So I think any ex parte submission that is limited to that issue, that is limited to that question, would be welcome. And I'll determine what, if any, weight to give it. But I do think review of the grand jury materials in camera, myself or the judge only, would be helpful and would put me in a far better decision. So I'll grant the government's request and I will accept those materials. Defense, well, he says to the defense, I was hoping to get an order out as quickly as I could. I know everybody's really busy these days, but defense, when can you file? We can do it as soon as possible. How about by noon? That's fine. That's fine. Prosecutors, when can you file the materials? Your Honor, I could file the materials shortly after this hearing ends. If you wanted the audio version, I could send that electronically too. Listen to the whole thing. I'm not sure if I could file it, but there's a way to get to your clerk. I'm sure we could do it within a few minutes after the hearing, sir. All right. Okay, says the judge. That's great. I'd ask that everything go through the clerk's office, provided to them. And again, just to be clear, when we talk about grand jury materials, Mr. Diaz, we're talking about, at least just for the in-camera review for the judge, all materials up to and including how the grand jury was instructed. Any other questions, comments in addition, right? Yes, Your Honor. We also have 14 exhibits that we can provide, which we may have already seen. Honestly, they may have released those in that motion, the response to the vindictive prosecution motion. Okay, says the judge. All right. Well, I'm going to enter an order to that effect, and I'm going to consider the ex parte submission. I'll review all the materials, and I'll get an opinion out as soon as we can. Does that work? Thank you, Your Honor. Thank you, Judge. All right. Anything else from the government? No, Your Honor. All right. Defense. Anything else? No, Your Honor. All right. Thank you all for taking the time to get on this call under such short notice. Have a great day. From the judge. All right. So we had that hearing take place. The judge did come down and issue an order, and we had that order come down. He says, this matter comes before the court. On November 7th, the undersigned ordered me, the judge, that a telephonic hearing be issued. On November 4th, we said any party who wants to submit additional briefing, do it. At the hearing, in its motion, the government said, let us look at things. And so I will. It is now ordered that I will do an in-camera review, and you shall submit your filings before the end of the day tomorrow, before noon, signed by the judge, William Fitzpatrick, who's handling the preliminary stuff in the Comey case. Now, here's more. Here was the additional briefing that came in from the DOJ. Okay, so Trump's attorneys, the prosecutors, are saying, don't give this guy any additional access until you look at it. They say, all right, look, defendant Comey speculates that the government may have submitted evidence subject to suppression, like they can get rid of it, or attorney-client privileges to the grand jury. He says he needs access, though, to decide whether or not that happened. But as we know, the grand jury rules have a long-established policy of maintaining secrecy of these proceedings. And the rules say he's not allowed to just search for evidence to see whether he can dismiss these things. Instead, he must produce a particularized, factually based evidence that shows where the problem was. And then he can make an argument for a dismissal. But right now, it's only conjecture. Second, even assuming he could prove that we violated his Fourth Amendment or attorney-client privilege, if those errors occurred, it's still not a basis to dismiss his case. But even so, go ahead, take a look. We say you should look at this, Judge. Look at the in-camera proceedings so you can confirm the baselessness of his claim that we shared anything with the grand jury at all, okay? We're above board here, Judge. Look at the files. We'll send them over. In fact, on October 13th, we moved for a filter team. He opposed that motion. He said, we just want the information. Give it to us, rather than having a filter team confirm whether there was any problematic materials in there. The court noted we had a couple of briefings, a couple of hearings on this. Then we had the defense. Comey came out and they said, well, we want to know if these prior warrants from 2019 and 2020 had undergone a responsiveness review. And defense counsel said that if the government had accessed both responsive and non-responsive materials, that would clearly violate the Fourth Amendment. So what did you get from the warrants and what did you look at? The judge asked the defense counsel, what information do you need that you don't have in the file to file a motion to challenge this? He says, well, what does the government have? What did they access and provide to the grand jury? The judge is now going to look at it. His desire to review the grand jury material is insufficient just because he wants to. It's been long established. It's indispensable. We have very secretive grand jury proceedings. This was codified in the federal rules of criminal procedure. And if you move for disclosure of this, you better have a good reason. You have to have a particularized need for the info, a blanket request for all the information. And see all this case law, we're fast. Case law. It's very well ingrained in our law. And now Comey, he's suggesting that he needs to know what evidence was before the grand jury so that he can challenge the use of the info that was seized from 2019 and 2020 when he was actually leaking into the media, in our opinion, via Daniel Richman. But he has to follow the rules. He has to show a particularized need. He hasn't done that. He doesn't get to review secret grand jury materials to try to mine for gold and find something. The rules say he's got to have more, and he's not doing that. Here, he was provided with 2 affidavits by 2 FBI special agents who possibly reviewed privileged materials. As their affidavits indicate, neither agent was involved in the grand jury presentation, so no privileged information was presented to them. And by suggesting that he needs to see this, he's turning the rules on its head. The rule doesn't permit a defendant to just go in and gobble up whatever they want. You can show that a ground may exist, but Comey can't, because neither a Fourth Amendment violation nor a privilege violation is a basis for a total dismissal. The Supreme Court has applied all these rules in Calandra, in that case, in Lawson, in this case, in grand jury proceedings, in this case, and on and on and on. United States versus Colasurdo, Rodolitz, also. Even Comey now, he cannot show that he needs this, and so we can't give it to him. Even assuming he could show that we did make some violation of the Fourth Amendment or attorney-client privilege, and to be clear, he cannot. The remedy would be to suppress that evidence at trial. You don't dismiss the indictment, that evidence just wouldn't come in, and the case would move forward. Now, although a grand jury consideration of privileged material is not a basis to dismiss this, if there was outrageous government conduct, maybe that could show a basis for this, but none of that has happened here. These are all speculative claims of some violations, and all of it is insufficient to compel us to give over the grand jury material. And even so, we'll give it to you, Judge. And the judge said, we'll take it. We're going to show you, we're going to give you these materials and show you that Comey's whining is completely and utterly baseless. Signed by Gabriel Diaz, shout out, on behalf of Lindsay Halligan's team in the Eastern District of Virginia. So this case is marching forward. We can see that the judge's final proceeding minute entry says, this matter came for a status conference. The court now requests the defense submit ex parte any information so I can look at it. They said no problem. The court requests the government also produce anything related to the grand jury, orders to follow, and of course, we read it. So the Comey case marches on, and we'll see what the judge does now that they got those docs delivered. You can see Trump's DOJ filed those minutes right after, audio files and documents received. So we'll see what the judge says, but we're learning more and more about this case. It's not as thin as they said when Lindsay Halligan first brought the charges, because it relates all the way back to 19 and 20, and Comey's been searched before with other search warrants, and he seems a little bit freaked out about that. All these documents now coming into the court. DOJ seems very confident here, Judge. His whining is totally baseless. Look at these documents, and we hope you'll agree.